We do not intend to transverse these grounds again, inasmuch as all relevant issues were fully dealt with in our judgment. There is no point in merely repeating or confirming them again. It must, however, also be remembered that an appeal is only aimed at an order of a court and not its reasoning. With those remarks as background, we deem it prudent to first discuss the legal framework within which we should consider the application before us. Our view is that the issues raised in the application at hand are best decided with reference to Sections 16 and 17 of the Superior Court Act number 10 of 2013. Section 17 deals specifically with applications for leave to appeal, and of relevance to us is subsection (1), which provides as follows, and I quote, small a, leave to appeal may only be given where the judge or judges concerned are of the opinion that, small Roman 1, the appeal would have a reasonable prospect of success, or, small Roman 2, there is some other compelling reason why the appeal should be heard, including conflicting judgments on the matter under consideration. Small b, the decision sought on appeal does not fall within the ambit of Section 16 (2) small a and small c, where the decision sought to be appealed does not dispose of all the issues in the case. The appeal would lead to a just and prompt resolution of the real issues between the parties. End of quote. In turn, Section 16 (2) small a provides, and I quote, small Roman 1, when at the hearing of an appeal the issues are of such a nature that the decision sought will have no practical effect or result, the appeal by me dismissed on this ground alone. Small Roman 2, save under exceptional circumstances, the question whether the decision would have no practical effect or result is to be determined without any reference to consideration of costs. I end the quote. Section 16 (2a) has to do with matters where the practical effect of the appeal sought to be pursued features. This is an issue squarely raised by the respondent. Mr. Tengrove SC for the respondent, whose heads of argument we also gratefully received and studied, submitted that because President Bashir had left South Africa, the issues between the parties had become academic, and that any order by the Supreme Court of Appeal, the court to which leave to appeal is sought, would have no practical effect or result. It is prudent to dispose of this issue at the outset. Section 17 (1) small b is clear that we should not grant leave to appeal should we be of the opinion that the appeal will have no practical effect. The argument made by the respondent is that, and I quote, the order under appeal directed the applicants to arrest and surrender President Bashir to the International Criminal Court for prosecution for various alleged international crimes. It was sought and granted on the basis that President Bashir was in South Africa and consequently subject to the jurisdiction of South African courts and capable of arrest by South African authorities. I end the quote. The argument is further that the order was not given effect to, as President Bashir had left the country, and that the appeal will have no practical effect whether it succeeds or fails. Mr. Gauntlet SC for the applicants argues that Section 16 (2) small a does not imply in casu. The argument is that the appeal will indeed have practical effect, as it will deal with the issue whether a sitting head of state enjoys immunity under international law and South African law, or is subject to arrest in this country, which will affect future international events in this country. The second basis advanced by Mr. Gauntlet SC is that this court retains the discretion in the same manner as a court of appeal to which leave is sought, to entertain an appeal even though the appeal will have no practical effect between the parties. The argument in this regard is that the matter at hand raises important questions of public international law arising from the interpretation of the Implementation and Immunities Acts. On this basis, Mr. Gauntlet SC urged us to exercise the discretion and grant leave. Our courts have on numerous occasions stated that a matter is moot, quote, if it no longer presents an existing or live controversy requiring resolution, which should exist if the court is to avoid giving advisory opinions on abstract propositions of law. End of quote. I refer in this context to the decision of National Coalition for Gay and Lesbian Equality and Others versus Minister of Home Affairs and Others, 2000(2 SA 1 brackets capital CC close brackets at footnote 18. In Janse van Rensburg NO and another versus Minister of Trade and Industry and another, 2001(1 SA 29 brackets capital CC paragraph 9, and JT Publishing Pty Limited versus Minister of Safety and Security, 1997(3 SA 514 brackets capital CC paragraph 15, the Constitutional Court stated as follows, and I quote, "This court has held that an issue is moot if it does not present an existing or live controversy. Such an issue is not justiciable." End of quote. The facts before us are clear that there is no longer any live controversy between the parties. We are further of the opinion that the appeal will therefore have no practical effect between the parties. For this reason, this application must fail on the basis of Section 17(1) small b of the Act. As we show in the following paragraph, we can find no merit in Mr. Gauntlet SC's argument that Section 16(2) small a is not applicable to this matter. Mr. Gauntlet SC has argued, as stated earlier, that the matter raises important questions of public law. This argument is based on a reading of Section 17(1) small a referred to above. In the first place, we do not hold the opinion that the appeal has reasonable prospects of success at all. The traditional approach which our courts have followed in the past when confronted with applications of this nature is to determine whether there is a reasonable prospect that another court may come to a different conclusion. In this context, see Commissioner of Inland Revenue versus TUCK, TUCK, 1989(4 SA 888 brackets capital T at 890 capital B. This approach has been altered by the Superior Court Act, as we show here under. Section 17(1) small a small Roman 1 provides that leave to appeal may only, I underline the word only, be given where the court concerned is of the opinion that the appeal would have a reasonable prospect of success. We are not of that opinion, and for the reasons stated in our judgment, President Bashir enjoyed no immunity from arrest or from prosecution under customary international law as a serving head of state. The essence of the case made out by the applicants is that South Africa's duty to arrest President Bashir in terms of the Implementation Act simply takes a backseat even when a known fugitive head of state of the International Criminal Court is in the country. The high water mark of this argument boils down to the following: that when domesticating the Rome Statute through the Implementation Act, this country's legislature deliberately created a situation relegating South Africa's obligations in terms thereof in favor of the Immunities Act. We have not been directed to such provision. In our view, had this been the intention, it would have been expressly provided as the Immunities Act was already in operation when the Implementation Act was promulgated. Our view is that it is clear that the provisions of the Implementation Act prevail over the rules of international customary law imported by the Immunities Act and are subservient to it. Article 27 of the Implementation Act applies, and it is clear in its terms. It expressly excludes heads of state from immunity and from prosecution. Article 27 provides, and I quote, irrelevance of official capacity. Sub 1, this statute shall apply equally to all persons without any distinction based on official capacity. In particular, official capacity as a head of state or government, a member of a government or parliament, an elected representative or a government official shall in no case exempt a person from criminal responsibility under this statute, nor shall it in and of itself constitute a ground for reduction of sentence. Sub 2, immunities or special procedural rules which may attach to the official capacity of a person, whether under national or international law, shall not bar the court from exercising its jurisdiction over such a person. That is the end of that quote. Also, the Constitutional Court has conclusively decided in National Commissioner of the South African Police Service versus South African Human Rights Litigation Centre, 2015-1 SA 315 Constitutional Court, that the South African government is bound by the provisions of the Implementation Act and must implement its provisions. It has enacted this domestic legislation and is obviously bound by it. One further aspect deserves mention herein. Mr. Gauntlet SC submitted that even if we were of the view that the matter was moot and also doubted that there were prospects of success on appeal, we were entitled by the exercise of our discretion to nevertheless grant leave, having regard to the importance of the matter and its precedent-setting effect. We do not agree. Nothing contained in the provisions of Section 16 and 70 of the Act grants us such discretion as contended by Mr. Gauntlet SC. To the contrary, Section 17(1) specifically prohibits the exercise of any discretion in this context and clearly states when and only when leave to appeal may be granted. The result is therefore the following. The application for leave to appeal is dismissed with costs, including costs of 2 counsel. I hand down this judgment. Thank you. The court adjourns.